Hello and welcome to the ARBV's three-part video series on the Board and the Architects Act 1991. This video will cover the complaints and disciplinary process.
The Architects Registration Board of Victoria is responsible for regulating the professional conduct of architects. The Architects Act provides for any person to make a complaint about an architect. Complaints must be formal, that is, a signed, completed complaint form accompanied by relevant evidence in support of the complaint. The Board receives an average of 10 complaints about architects each year. If a complaint is received, the Board sends it to the architect and the architect is able to respond in writing within 30 days. If you receive a complaint, you may want to seek advice. Although you don't have to respond, your cooperation and responses will assist the Board to decide whether the matter should be referred for further inquiry. The Board will then assess the complaint. In addition to any response from the architect, the Board can seek any other information or assistance. This may include obtaining further documents about the matter or obtaining legal advice. All relevant matters will be considered by two Board members who will make a recommendation to the full Board about how the matter should proceed. The Board may decide that the matter should be referred to an architects' tribunal for disciplinary inquiry, or it may decide that an inquiry should not be held. A disciplinary inquiry is an inquiry into an architect's fitness to practice or professional conduct. Whatever decision is made, it must be communicated to the complainant and the architect in writing. If the Board decides not to refer a matter to inquiry by the Architects Tribunal, the complainant can seek a review of that decision by the Victorian Civil and Administrative Appeals Tribunal, commonly referred to as VCAT. If the Board decides not to hold an inquiry, it may issue a written advice to the architect about the matter. If the Board decides to refer the matter to an inquiry, it will appoint an Architects Tribunal. An Architects Tribunal is made up of members who are on a panel chosen by the Minister. Board members cannot be on a tribunal panel. The tribunal panel will be made up of 3 members. One must be an architect, one must not be an architect, and one must be a representative of consumer interests. Of those 3, one must be a person with legal experience and knowledge. The tribunal issues a notice of inquiry to the architect which sets out information about when the inquiry will occur, what allegations are made, and what determinations could be made by the tribunal if the allegations are proven. The tribunal may conduct the inquiry as it sees fit. It must obey the rules of natural justice. It must also act with as little formality and technicality as the matter permits. The Board is legally represented at the inquiry. The Board's lawyer will be present to present evidence in support of the allegations and make submissions to assist the tribunal. An architect can be represented by a lawyer or can represent themselves. Usually the process will begin with an administrative hearing called a preliminary conference. The chair of the tribunal will preside over this initial hearing on his or her own. At the preliminary conference, the tribunal will issue directions for how the matter will run. It will ask the architect and Board to exchange documents before the day of the hearing. It will also decide on how long to allow for the hearing, taking into account matters such as the amount of evidence and how many witnesses are required. The type of allegations that may be made against an architect include acting carelessly or incompetently, acting unprofessionally, which includes any breach of the Architects Code of Professional Conduct, being convicted of an indictable offence, which are more serious criminal offences, and obtaining registration by fraud. If a tribunal found you guilty of any of these matters, it may decide to do one or more of the following things: issue you with a caution, reprimand you, require you to undertake education, impose a condition on your registration, impose a penalty of up to 50 penalty units, which is currently approximately $7,750, suspend or cancel your registration as an architect. The tribunal can also order that you pay an amount towards the Board's legal costs. As soon as possible after making a decision on an inquiry, the tribunal must give the architect a written statement setting out its decision. If you are not satisfied by the tribunal's decision, you have 3 months to issue proceedings in VCAT seeking a review of the decision. The decision of a tribunal becomes the decision of the board, so the board will enforce the decision or attend VCAT if you seek a review. At VCAT, the whole case can be heard again. The VCAT member will stand in the shoes of the tribunal and decide whether the tribunal made the correct and preferable decision. VCAT may substitute its own decision, agree with the decision of the tribunal, or send the matter back to the tribunal to consider again. It is important to remember that the reason why architects are subject to disciplinary inquiry is to protect consumers by ensuring that the professional standards required of architects are being upheld and that the profession of architecture is not brought into disrepute. This is an important part of what it means to be a professional and to hold registration to deliver architectural services to the exclusion of those who are not registered.